All right, so look, I'm here with Damien Grant from Waterstone Insolvency again in the wake of COVID-19, where ironing is optional and shirts too. Apparently, Damien, how is lockdown treating you?
I can't complain. I've got a nice house, in the warm embrace of my family. So what's not to love?
Wow. So look, we're here to talk about a topic where I've had some questions on, and so I thought it would be good to answer these with you. And it's around the regulation of insolvency practitioners, and it's coming into force in June this year. And this is going to be very, very relevant for the business community because I think we can expect a bit of a tsunami of insolvent businesses heading to the hands of insolvency practitioners. So, this regulation that's coming is probably quite well timed for that event. And as an insolvency practitioner yourself, what better person to talk to about what regulation actually means on the front line of practice. So, Damien, I mean, how is regulation going to impact the way that you practice currently?
Probably the biggest change is going to be oversight. So at the moment, insolvency practitioners are completely unregulated. So there is very little ability for creditors or shareholders who are disgruntled or unhappy about what has happened to go anywhere. The only place you can really go is the court. And in our experience, courts are reasonably reluctant to hold liquidators to account. It can be quite surprising. We've been involved in a couple just recently where we wanted to force a liquidator to hand over something as simple as voting records to indicate who voted and who didn't. And I think that the reluctance of the court to provide aggressive oversight over the liquidators has allowed some liquidators to take a fairly laissez-faire approach to say, well, once I'm appointed, they are prepared and willing to do anything to remain in office. Now that really applies, I think, primarily at the fringe. So there's probably half a dozen people who I would describe as real cowboys out there taking appointments. And chances are that none of those people are going to come through the regulatory regime. So in that sense, it's a good thing. It does also allow that if you're not happy with what your liquidator or the liquidator involvement company has done, you've got somewhere other to go other than the courts. And so that's a much cheaper form of holding a liquidator to account. And I also think because this thing has been running by cans, in terms of the auditing and other bits and pieces, liquidators are going to be much more wary about, if I do this thing, somebody is going to potentially look at what I am going to do. And if I do something outrageous, somebody can complain. So I think at a base level, you're going to see an improvement in behaviour of the liquidators who are acting out there. So they're going to have to keep better records. They're potentially going to need to take file notes of the decisions they've made. So if you decide not to prosecute, to go after a director for reckless trading, there's a requirement now to take a contemporaneous note as to why you did not do that. And so there is an ability now to dive down and review what liquidators are doing. So I think at one sense you are going to see an improvement in probably box ticking in terms of that behaviour, but it's that accountability that at the moment simply isn't there, and so I think that's going to be a good thing. The ultimate question though is whether it's going to result in an increased distribution to creditors. I'm not as confident. Traditionally, unsecured creditors don't get much or any of a distribution, and I think some creditors have looked at that and blamed the liquidator or some other non-regulatory process. But I think for a lot of the cases, it's simply going to be that there's nothing to distribute, and so that's going to be a really hard thing to change.
But also
the change that I wanted to see happen, which didn't happen, was I thought it should have been much easier to fire the liquidator. But unfortunately, once a liquidator has been appointed, it's still going to be very difficult to replace him. But at least now disgruntled creditors and shareholders will have somewhere other than the courts to go.
Yeah, and I suppose if we just take a step back and consider, what are your qualifications to be as a liquidator? And I remember this moment in court where my witness, who was a liquidator, was asked that question. What are the qualifications of a liquidator? And the answer, which made me cringe as the lawyer for that liquidator, was any idiot can be a liquidator, and I am that idiot. I mean, it's a very low bar, right? So you've got to be over 18.
I'd just like to point out, Mr. Norling, that everybody in the courtroom except my lawyer laughed at that particular joke, including the judge, and we still won.
We did.
But it's true. So long as you're over 18, not disqualified by some form of related party conduct and not under the control of the Mental Health Act, then you can be the liquidator. But the reality is that the market in some sense works, because if you are clearly manifestly inadequate, you're still going to get some appointments. But the vast majority of appointments are taken by insolvency practitioners, whether I agree with their style or not. You could and should define them as being within the industry. So it's actually a really small number of insolvency practitioners that I would consider rogue or dodgy, and they're taking a really small percentage. I think, and I actually think that people are focusing too much on that. I think what people should be focusing on is the fact that now that there is regulatory oversight, how can you as a creditor or as a shareholder in a liquidation use that regulatory oversight to improve the performance of the liquidator who has been appointed? And I think that's where the real change is going to come, not because the number of appointments taken by rogue liquidators, although they can be really annoying if you encounter one, is a really small part of the market.
Because a rogue liquidator, they're going to do things that is, unethical. They're not going to be complying with your obligations, and I've seen a lot of that myself. But I suppose there's this other part of the market where, if you're a creditor, you're going to be frustrated, and this is not necessarily targeted at rogue liquidators. This could be the standard big five liquidator firms, and they're charging their fees like a wounded bull. I mean, you're talking about hundreds of thousands of dollars, millions of dollars in fees, and this is pretty widespread. And I see this quite frequently. And if you're a creditor, to review the liquidator's fees, you have to go to the High Court. And practically speaking, creditors just don't do that. They don't have the war chest available to take on a very large accounting practice. So, I mean, do you think regulation is going to change that at all?
I think it can. I think if you are one of the big five, and you know that your actions could well be subject to the review of your peers, then it's going to potentially moderate your behaviour in one sense, because there is a degree of accountability that didn't previously exist. But counterbalancing that, the insolvency industry is really small. And so it's a fairly tight-knit group. And the proof is going to be in the pudding. So as we get into this regulatory regime, how aggressive is the industry going to be in holding its own to account? And there I'm probably not particularly optimistic. I do like, because at the moment there's one regulatory body that's been approved, and that's RETANS. But RETANS have, I think, quite cleverly or correctly allocated the supervision and the oversight out to CANS. So given that there's probably 50 insolvency practitioners taking 80-90% of the market, that's too small to regulate itself. And so they have they've outsourced that to CANS, which is a much larger organisation, Institute of Chartered Accountants, to do the review. And we have seen CANS take their own members to account, a bit like in some ways the Law Society does.
Mm.
But given that the sort of people, you're talking about the big five, and these are your large professional accounting firms, how willing is CANS going to be to bring those to account? Look, we're not going to know until that process actually starts. And as you said, at the top of the scene, there is potentially a tsunami of insolvencies happening. And so it's potentially going to get where we're dealing with 2,500 insolvencies a year, which is what we're dealing with. In fact, we're going to drop, not a lot, but we're going to drop the number of people taking appointments, and we are going to increase the number of appointments that those individuals still in the market are taking. And so it's going to be interesting to see how, from an infrastructure perspective, how good CANS is doing as holding its own members to account. So look, there's pluses and minuses. It's certainly a huge change from where it has been in the past. And also don't forget that for your larger insolvencies, there's normally a bank with a general security over the entity. And so whether the bank appoints a receiver or not, the bank is in a lot of cases, as a secured creditor, the one who's calling the shots. And so that's where most of the assets and money end up being. And so and that has its own form of self-regulation. So a bank typically will appoint an insolvency practitioner that it has a relationship with and has some confidence in. So at the big end of town, where you've got large insolvencies happening, I don't think you're going to see much of a change. Where this change will happen is the small and medium enterprises, which I think is where the tsunami is going to hit.
Yeah, and I think, but in saying that, I mean, the IRD is responsible for liquidating a large volume of companies due to, unpaid tax, and you only have to be in the liquidation list, to see how many times the commissioner's lawyer has to stand up and progress a liquidation. And typically, those files will be, small companies, but they do go to the big end of town. It's the big accounting practices that generally are on the IRD's panel. And I suppose one thing that I've always found a little bit difficult is getting information from a liquidator that might actually be helpful to hold them to account. Like, for example, if I act for a creditor and the liquidator is clearly overcharged, by many hundreds of thousands, it can be very uneconomic for that one creditor to sue a big company. So one thing that would be very helpful is to get a list of creditors, and we can contact the creditors and say, hey, look, this is what we believe is happening. This is what we want to do. Do you want to come on board? And then as a class, you can actually take some more economic action. But liquidators don't want to give that list for very obvious reasons. And so we are operating in a space where we have to get that through alternate means, which is difficult. So do you think regulation is going to open up the information channels or not?
Yeah, it might do. I mean, there is a statutory requirement in the first liquidators report to provide a list of known creditors. But I think the large firms already do that, to be fair. Some of the smaller firms take a bit more of a laid back approach to it. But I mean, where people, creditors want to replace the liquidator, and that can be a real struggle. But where you're dealing with a large firm, as the EBIT one is a classic example, there you had a respectable insolvency practice that provided the full list, and then when I went to challenge that liquidator and replace it, to be fair, that insolvency firm acted with absolute integrity, and published the list and ran a really clean process. But also, obviously, we've been involved in other cases where we've tried to replace smaller liquidators, and they've taken a much more brutal approach, not publishing the creditors as they are obligated to, and then in some cases, blatantly making creditors up. And it can be very difficult with the court process to get that through. But you just come back to what you're saying, getting a list of creditors together and taking a class action. you still end up with a free rider problem. Because if you have one creditor who's saying 20% of the creditor pool, and they say, look, I don't care, I'm not going to get involved. If the other creditors take the action, win, then those creditors, the creditors that didn't participate, still get to participate in the outcome. And I think that's one of the reasons why it can be really difficult to get those creditors to put their hand in their pocket to help the general pool of creditors when they don't necessarily get an advantage over the rest of them.
Yeah. Yeah, no, exactly. It's it can be difficult if you are a creditor and in that situation. So look, I think all in all, regulation is a good thing. I think that there will be some positive change flow out of this, and like you say, that there will be a number of practitioners that just don't make it through, and that's going to be quite impactful for those people that would otherwise have had to deal with them.
Well, I mean, there's two other things happening as well. One, there's a small number of chartered accountants who might take 3 or 4 insolvencies a year. So this is not part of their core business, but they do it. They are opting out of the insolvency regulatory regime, so they are just leaving the game. And I actually think that's a shame, because a competent accountant taking a small insolvency, and typically they put quite a lot of, almost a disproportionate amount of effort into the insolvency, can get quite some good results. So that's leaving. But the other thing is that regulation is putting a pile of costs on those of us who remain. And so those costs are going to have to be borne somewhere. And so ultimately it's going to be borne at the cost of liquidation. And so the hope, I guess, is that the improvement of behaviour on the insolvency industry as a result of regulation and the oversight that's going to come from cans and recans is going to more than outweigh those additional costs. And bear in mind that under current regime, what a liquidator charges is pretty much at their discretion. There isn't a lot of incentive for a liquidator not to overcharge the file at the moment, because once you are appointed, there is a very limited window for creditors to challenge you. Once you survive that window, then you're home and hose. It's virtually impossible to replace a liquidator. And so there isn't a lot of, so the liquidator's got to pull the money. Whatever fees they take from their estate, they know that they're almost not going to be challenged. And so the argument that it adds a layer of cost onto the industry, look, that's absolutely true. But I am wondering whether the increase in oversight is going to make liquidators a bit more circumspect in what the fees are going to be, because they're talking about annual reviews. And so somebody comes into your practice and says, right, I want to see all of the fees on the last 2 years worth of files, and I want to see the notes that justify those fees. I want to see the time records. I want to see the consent from creditors and full approval. So I think forcing liquidators to justify their fees and their invoices may actually result in lower invoices. But the real thing I would like to see is the liquidators take a far more aggressive approach, where they see an opportunity for recovery. And we haven't typically seen that in the insolvency industry. And look, I understand why, because going after debtors and pursuing insurance claims and so forth is expensive and it's hard and it's uncertain. So it's possible that in this regulatory environment we may see an improvement in behaviour in that area, but we're going to have to wait and see.
Yeah. Okay, well, I think that's a wrap.
That's a good.
Perfect.
We haven't gone on too long. Well, we have. We've gone on for about 20 minutes, but it's been a good conversation.
All right. Cheers, Damien.
Thanks. Cheers, Brent. Bye.